I wanted to take a show of hands first. Done? Mine?
Yeah.
Who here doesn't speak Hebrew? You think you can kind of learn quickly?
Or Google Translate?
So I think we have no choice, right?
Yeah.
He will take me after.
No, you're not the only one. So I think we need to keep this in English, although we thought we might be able to switch. So obviously, with all due respect to Europe and the US, to different countries around the world, what we're really interested in is Israel. And initially when the day started, I said, this isn't just some theoretical sort of law school class about Roman law, right? We learned Roman law in law school, but this is something very practical because it does have global impact. Plus, Israel also is moving on its own towards a more, can we say, European type model, maybe, or maybe it took some of it. So I should introduce you first, right? So Limor is head of strategic alliances at the Privacy Protection Authority. So the privacy regulator here in Israel. Dan has his own law firm that does privacy and IP law, right, Dan? And Orly is Microsoft's counsel here in Israel. So maybe start with you, Limor, and I think what we want to explore in this session are some of the similarities, but also some of the differences between the two models, the Israeli model and the European model, and the challenges that this overlap or gap causes for Israeli companies. Sorry, use this, Limor. I think it's better.
Better? Okay. So firstly, I think Israel is not moving toward the European framework because we're already there. We have something that is considered adequate by the European Union has been declared. Israel's privacy framework has been declared in 2011 as adequate by the EU. I think that when comparing and contrasting GDPR with Israel, you need to bear in mind that Israel has various layers of privacy norms, starting with a basic human right to privacy, and then the privacy protection law, privacy protection regulations, both to deal with data security, the new ones, very elaborate, and regulations that handle data transfers through borders, etc. And we have the privacy protection guidelines, and we have the precedents of the Israeli Supreme Court. So you need to take this all into account when you compare and contrast Israel with the GDPR. And as far as we're standing right now, Israel is still considered adequate by the EU. So,
but even with the adequacy, I mean, adequacy doesn't try to create or aspire to identity, right? There are differences, but maybe before we get into specific differences, give us your little spiel about the regulations. So, what are the regulations about?
So the new security regulations are. Our aim was to create a unified standard that is applicable throughout the Israeli market, whether you're a corporation or a business or even a small business or a public body or a ministry. Everyone who is processing personal data within databases, computerized databases, needs to adhere to the security regulations. And I think that one of the if you can say, innovations and perhaps even revolutionary idea was that we're taking something that, as far as most of the world is concerned, is handled by standards which are voluntary. You can adapt them and you can do something else. And this is an instance when we've took the security standards and created them in the legislation, making them law, making them something that you have to comply with. So I think that's a huge change. Another special thing about them is that if you're a lawyer and you read them, they feel very technical. If you're an IT person and you read them, they feel very legal. It has its pros and cons. I think it's complicated for both professions, but it also, I think, signifies the privacy professional today, having to be both literate in technology and in security and regulations.
And if you don't comply with the regulations, 4% of annual global turnover?
Well, not yet. So in terms of sanctions, currently there are no monetary sanctions on non-compliance with the security regulation. This is something that we expect to be handled in the next amendment to the Privacy Act. These are regulations. They cannot create sanctions within them. They do create the norms. But I would advise organizations in Israel to take them quite seriously for a few reasons. First, we enforce them. We do analyze security breaches, and we will conduct audits on implementation of the security regulations. And everything we do usually is public afterwards, and I think that the public is quite concerned with data breaches and with non-compliance to security by organizations. There's also a new data breach notification duty, which is new to the GDPR as well at the same time. And the data breach is something that we're also putting a very special emphasis on. So we've announced our policy for the coming year for the implementation of the security regulations. Organization that will inform us and report data breaches will receive more lenient enforcement. On the other hand, if you do experience a data breach and you fail to report, then the enforcement procedure would be much more public and forceful.
And you did just publish an enforcement action.
We did just...
I can't remember against whom.
It was against Ituran.
Ituran. Okay, Dan, what do you think?
I think a whole lot of things.
Tell us.
More specific questions.
You've got the stage now.
I'll just say something, for as a starter, as something in general about Israeli companies and their regulation and compliance needs, and that's from my own perspective with companies that I work with, and most of them work both in local environments here in Israel and abroad, and the new regulations, new data protection regulations are quite challenging because GDPR and Israeli data protection laws are, in essence, are very similar in principle, but the practice is quite different. So we have separate spam laws. We have outsourcing services are governed by others. We have different kind of DPAs, data processing addendums, than the GDPR requires. So in essence, the practice is different. The information security regulations, the requirements under the new regulations are quite different than the general requirement that we see under Article 32 to the GDPR. Breach notification requirements are somewhat different. And think, for example, of the average high-tech company that was established here in Israel, and some time later on they will establish their subsidiary in the US, so they have to consider some regulatory issues under US laws as well. Some of them, for example, may process health-related information, so they need to think about HIPAA as well. And they need to put in place internal compliance procedures and policies under HIPAA, which is again different than what the GDPR requires, or here or the Israeli law requires. So Israeli companies, technology-driven companies that face the global sphere, in most cases will face more than one set of regulatory requirements, and this could be somewhat challenging. Just to set just one example, for Article 28 of the GDPR, for example, requires a processor to delete data when the controller asks that processor to terminate the service or following the termination of the service. The processor doesn't have any discretion in retaining the data unless there is an EU law or an EU member state law that requires to retain the data. But what if it's an Israeli company that needs to retain the data due to local Israeli laws? That's something that doesn't have an answer under the GDPR. So if an Israeli company needs
Which Israeli laws, for example?
audit laws,
Tax laws?
tax-related laws, of course. There are a whole bunch of laws that require you to retain data for. And what about retaining data for potential legal claims, for example? Are you allowed to do it as a processor? Probably not, if you know.
Orly really wants to speak, but you have her microphone, so I think.
I just wanted to comment while Dan was speaking about the right to erase or to be forgotten, then I'd say that even in the EU, it's not an absolute right. So if in the EU, in several countries, there's a necessity to keep documents for either law processes or for tax or for regulation or other regulation, that would not be an absolute right to be forgotten or an absolute right to be erased, the same as in Israel. So I think that I defer you in the gap or the depth of difference that in practicality. I do think that there are different rights, and some of them go to a wider extent in either places. So the security, for example, is much more elaborated here, but does apply in the EU as well. And I'm not sure that it's easier or more or better to think about how do I comply with two sets of regulations that apply to me in variances that might be very small, because I do think that if we double-click on each and every one of them, even the new ones that came with the GDPR, I think that in practice, the difference is not that big.
So Orly, your company obviously, I think, operates in all 200 or however many countries there are in the world. You've actually litigated some of these conflict of law issues very recently against the U.S. government, Microsoft Ireland case. How do you see this, gap or overlap between Israeli and European law generally, and maybe specifically as it refers to the cloud?
Okay, so as a cloud service provider on an international scale, hyperscale, worldwide, and so on, for me, GDPR is something that was obvious that I will comply with. We actually supported part of it from 2012 already with the discussions, and understood that we would have to comply across the board. So once I have put upon myself to be compliant with GDPR as soon as it comes in, I've even took that further step and committed to apply it across the board beyond EU. First of all, it's easier for me once I do have a standard to comply with across the board, across my services and across the world. And second, it's harder for me to know who's the data subject, where is the data coming from, is it private data? So I would go for the highest standard. So if I have two, for example, today, as an Israeli company, I would look at the gaps, I would look at the differences, and probably aim to align or to harmonize on that bar. As Microsoft, I committed, as I said, to comply with it across the board, and I think that's, as an international company, and a lot of international companies that do, this poses something to local markets as well, because this is kind of setting the standard now. Because now I need my suppliers to comply with GDPR as well. So if we talk about Israeli companies, for example, if they are providers or suppliers of international companies, this is coming their way anyway.
So even before you are, even if you are only operating in Israel and so on and so forth, if you are a provider of an international company, GDPR is really important to you. But I wanted to take this discussion a little bit different and a little bit closer to what Limor was aiming at, and to actually double click and to see, are we really facing these kind of gaps? Because in my discussions with Israeli companies, that's where I'm actually heading. I was very interested in that. We took our outside counsel and asked him to do, Eyal Sagid, that kind of double click on the work. And we realized the difference or the gaps are very small.
Yeah, if I can add on that, Omer, then the core principles of the European framework are in existence. Israel has purpose limitation and consent requirements and transparency requirements and right of access and rectification. And the new security regulations are also adding data minimization principles and risk analysis and documentation requirements and outsourcing principles. So I think that if you do the gap analysis, full Israeli framework towards GDPR, then you're actually in quite a closer place than people imagine.
Dan, you agree with this, that there's hardly a gap?
Not entirely. Just one note, Orly. I wasn't referring earlier to the right to be forgotten. I was referring to the actual agreement between a controller and a processor, and there the processor doesn't have any discretion but to delete the data post the termination of the services. So this is something that Israeli companies need to face with.
But even in Israel, you have an obligation today not to keep excessive data or beyond
Yes.
the time you need.
Within the security regulations.
But that's a bit different because there are some carve-outs, and that you can continue
I'm not saying it's
retaining the data for archive purposes and for legal actions and et cetera. This is not something that exists under Article 28 of the GDPR.
By the way,
But-
can the
I think-
security regulations set new principles that weren't articulated in the law, but wouldn't it
Yeah.
make them ultra-virus?
Well, good question, but I want to say something a bit more general. And I think that we should bear in mind that while we're lawyers and we're used to doing this very specific fine-tuning and very small resolution, we need to look at the public. And the public sentiment right now and recent events and the direction we see things going is that consumers are expecting better outcomes from organizations. I think that it doesn't go well with consumers and with users when an organization, a multinational, says, I will treat these citizens differently than those citizens because they originate from a different continent or country. I think that that's a bigger question that we should be asking ourselves, and that's a bigger policy issue that needs to be addressed. And for that purpose, I think that a declaration of a multinational, I will treat all my customers the same, is an approach I respect.
Yeah, so far I think Microsoft is the only company, as far as I know, that actually went, although it didn't say it will comply with GDPR, it said it would implement data subject rights, right?
Yeah, and processing.
Done.
You were all outside,
Yeah.
you guys.
Yeah.
I think that we need to remember that when we're talking about compliance to data protection regulation, most of the companies are not Microsoft or the Googles or the Facebooks. Most of them are small, medium-sized companies that need to set their priorities.
Magazanik Hashmal.
Even smaller. and I think that you do need to set your priorities because there are a whole lot of requirements that you need to attend to and to pay attention to. And in essence, when you relate or when you think about whether I need to go through a certain compliance program in order to meet requirements under a set of regulations, I need to make sure that I can do it, and I need to set the priorities right, that in a manner that I will attend to the probably the riskiest regulation that I need to handle. And in essence, when I'm talking about differences, it's not that the requirements under Israeli law have less burden on companies. To some extent, quite the contrary. But when you need to go through into to decide how do you want to tackle the regulatory requirements, you need to go through a compliance process. You need to make the proper assessments, the proper mapping. You need to go through a proper gap analysis in order to understand what issues do you need to implement. And you cannot do it both ways. You cannot take two separate sets of regulations and at the same time do both of them. That's for the average small, medium-sized company, that's entirely impossible. So what happens in practice is that these companies need to set the priorities. Most of the companies that most of their business activities are here in Israel, they would probably opt to first go with the Israeli data protection laws and make the necessary arrangement in order to comply with them. And on the other hand, an Israeli company, the average Israeli company, which most of their business, if not all of their business activities, are done throughout the world, mostly in the U.S., probably in the EU, and other places in the world, they will probably opt for GDPR compliance first, because this is because they know that they will be out of business if they don't attend to the requirements under the GDPR, and only at the later stage will think about the additions or other requirements under Israeli law that they need to attend to. This is the actual reality.
So let's talk about these additions, talk in this direction, for example. So assume you're here in Tel Aviv and you're complying with GDPR. And it's a humoristic assumption, but let's assume that. What might you not be complying with still under Israeli privacy law? There's like the funky provision in the data transfer regulations, right? Section 3.
Yeah,
but what? So give us like a little menu of the things you're still facing.
Well, just about every type of requirement is a bit different under Israeli law. It's not that entirely different, and that's the idea, and that's practice. Because the right of access would be extremely similar to the right of access under the GDPR, but it's not identical. And you need to make sure that you do everything according to Israeli law as well. And the data transfer abroad is different. Again, in some manners, it resembles the data transfer mechanisms under the GDPR, but they're not identical. They're somewhat different. Breach notification is different. You as a holder, database holder of a database, rather than the owner, which is somewhat resembles the data processor. You need under the information security regulations, you need to notify the regulator as well. You're not exempt from notifying, and that's different. And you don't have an explicit exemption, for example, to as an owner of a database, not to notify the regulator if the data was encrypted and the encryption keys were not compromised. That's, again, different than the GDPR. And that's not mentioning that if you're a U.S. company, then you need to make a separate assessment whether a breach notification is required under U.S. state laws. And again, these are different laws. The breach notification acts under state laws are quite different.
Well, and if you're a bank in Israel, you need to also notify the supervisor of banks. And if you're a public company, you might have reporting requirements to the stock market.
So
Yeah, that's right.
Omer, can I add just a few things that I think it's important for everyone to know that we've tried to make transparent to controllers and processors in Israel with respect to what Dan was saying. So firstly, we published a few of our policies. One of them has to do with breach notification. And it's a document that explicitly states what types of incidents would be considered a breach that needs to be reported and what not. And for example, an encrypted database where the keys were not tampered with is exempt from notification by our policy. So that is something that is available to everyone at on our site. Another thing that Dan said before that I think is worth stopping on is the difference between large organizations and small and medium-sized businesses. And I think it's worth letting the people here know that the security regulations come from an approach that is considerate and takes into account that there are different types of organization and they should have different sets of requirements. And so we've created a model that has 4 different risk types within the regulations, and it builds as you go from the basic risk level to the medium risk level to the high risk level, and then your requirements are added as you go along. The fourth is a one-person business, a business owned by an individual, an individually owned business.
Questions? You have the regulator, you have local council, and you have global company. So I just want to remind me, feel free to raise your hand to ask any questions. Okay, Dan, let's talk a little about consent. The Israeli law is very consent-focused, right? It's the only legal basis for processing under the Israeli law. Is it always required? And when required, is it the same kind of consent that we've talked about extensively over the last couple of hours?
Well, I would be happy to hear the opinion of the regulator, whether we're talking about the same level of consent requirement as the GDPR requires. But our law, first, the extent of the notice that is required under the protection of privacy law is not correlated with the requirements under the GDPR under this Articles 13 and 14 today. So there's a bit of a difference between what the GDPR requires at first from a notice. And then as to consent, I think that, as I understand it, at least from the view of the Protection of Privacy Authority, the notion of granular consent is something that the authority advocates to. So this is something that I assume that Israeli companies would need to face with as well. Elaborate notices, consents which should be right to the point with options for the more options for the consumer and the end user to decide whether to consent or not. From a practical perspective, this is something that we're not that the Israeli market I think needs some additional time in order to adjust to it. We don't see in practice yet the evolution of consent that we've already see in worldwide and specifically in EU websites and applications and other service providers. But I assume that this is something that eventually would be apparent more and more with Israeli vendors and website operators, etc.
Limor?
Well, I think our policy and our enforcement work, which is public, gives indications of our attitude toward consent and also guidelines that we've published. The Israeli law recognizes implied consent as well as explicit consent, and I think that in the context of a contract and the fulfillment of a contract, you could use both on either cases. There are also protections, and Article 18 of the Privacy Protection Law has all sorts of protections to those who use personal data in cases that may have been considered as infringements, but these protections create the ability to not be litigated against. So I think it's a bit more complex than that. It doesn't articulate the exact consent and other legitimate purposes in the GDPR, but you can read them into that and through our guidelines.
So aside from consent, you can base data processing on other legal grounds? Under Israel, because we talked about, the 6 different bases.
Right. Well, I wouldn't say it go as far as to say that. Consent is the first course of action, and then after that you have various circumstances built on consent or various protections in Article 18.
Only consent under Israeli law?
Yeah, so once again, as I look at it in the GDPR, it is explicit consent, and in Israel, it's explicit in consent, and then there are circumstances where implicit consent would qualify, and then if we look at the circumstances or the cases where it would apply, then it would cover the same ones that are under the GDPR for explicit. So it would be for based on a contract or a legitimate interest or others. So I say there's a difference. This is explicit, this is implicit, but if we, at the end of the day, where it would cover, it would be the same processing circumstances or occasions that would qualify under both.
Oh, consent in Israeli law is defined as informed consent, implied or explicit, right? So it absolutely could be implied.
Implied.
Yes.
Implied.
Question, yeah, in the back.
In previous sessions today, we discussed the territorial scope of the GDPR, and basically the GDPR could apply to a non-EU company that provides online services to persons in the EU. What about the Israeli regulations with respect to non-Israeli companies offering services in Israel?
Well, this is also something that has become public in latest news, so I think you can infer from that. We've expressed our policy and our belief that when international companies operate in Israel in Hebrew towards millions of Israeli customers in shekels, make profits here, then we expect them to also abide by the local privacy regulation.
Wait, but I think in the court case, they asserted jurisdiction, but said that California law applies to some extent at least, right? Can you provide details, Dan?
It applies to Google Ireland. Yeah, California law applies to Google Ireland to the claim against
Facebook.
Google. Facebook Ireland, sorry, yeah.
Yes. Gabriella, yeah.
Just for a comparative law perspective, is there a right to compensation? Can individuals go to
Yes, yes. Privacy infringement in Israel is a tort, and a person can sue for compensation. There is also up to 50,000 shekels compensation without proof of damage, and in severe circumstances up to 100,000. And there also have been actions, class actions on through the Israeli consumer protection law, but based on privacy infringement.
That's
So-
4% of the global annual turnover.
But that's actually an interesting example of looking at the gap in an opposite way, because in Israel, whereas in the EU, it's not that common for class actions, then in Israel, it's kind of it's almost a sport. I know there's about several milliards shekels that are on the table as we speak on these kind of cases in Israel today as far as privacy is concerned. And it's also a criminal offense.
Yes, that's true.
But that's an interesting construct. So the class actions have to be brought under the Consumer Protection Act, asserting a privacy violation. You can't bring a class action under the Privacy Protection Act? Limor.
Not at the moment, no, but that's the mechanism.
Well, it's not that uncommon, given, for example, Section 5 of the Fair Trade Commissions Act. Class actions are established under the Unfair and Deceptive Trade Practices. So conceptually, it's quite similar. Yeah, it's based mostly on deception.
Yeah, but it's also, Orly just added that in Israel, an infringement of the privacy law may also be considered criminal offense, and the PPA as a regulator has criminal enforcement powers. So in severe cases, we may choose to conduct a criminal investigation,
The population register, right?
The population register, that was, quite a few years ago, and after that, we've conducted several criminal investigations on illegal trading of medical data and so forth.
Yes, sir.
Oh, I wanted to talk about the scope from the other.
Yeah.
The other direction, meaning an Israeli company that deals with foreign citizens' data, not Israeli citizens. Does the law, regulation, data
Interesting.
security laws still applies?
Limor? Israeli
I have-
company that only
Israeli
processes
company?
data about Taiwanese. Chinese.
I think they better get a legal opinion from a private sector attorney.
Dan, you fit the bill.
Well, it depends on the circumstances.
What he's saying is he'll tell you the billable hour rate. That's what it means. I'll translate lawyer.
It's a case-by-case analysis. Sometimes.
You had a question here, sir? Yeah.
On the 25th of May, the European Data Protection Board was appointed. And this should interact with Europol EC3, which is the police meeting. So I wonder if in Israel you already have an experience on privacy by design for the citizens and the police, what we call in Italy the digital police. What kind of interaction there is when there is a law and you have to implement it. There might be a conflict among the same organizations.
I think it's for you, Limor.
Yeah, I'm trying to gather that. Okay, so privacy by design is a concept that we've been implementing in Israel for a few years now within government projects. This is something that we, as the Privacy Protection Authority, have promoted as our professional opinion in various cases where the government has established new projects collecting personal data of citizens. And various privacy by design principles were implemented, be it the credit history database or other databases that were established here in Israel in the past few years. So even without the GDPR making it something that you must do, we believe as a Privacy Protection Authority that it is something that the government should do. So it's been done. We have experience with that.
So for every data security framework, and I think we'll see this in privacy also, there is sort of the initial compliance level, which is the legal exchange of contracts, data processing agreements, data transfer agreements maybe. And then there is the drill down into the organization, which oftentimes in security is by implementing standards. So 27001 or 27018 for cloud security. Will the authority seek to enforce at that level of granularity? Like how deep will you look into organizations as they purport to comply with these regulations?
Okay.
And maybe Orly, I'd be interested to hear your view on that.
So there are a few levels. At the first level, in the principle of implementing the security regulations, the regulations are baseline. They're the minimal requirements. They're high level in a way that requires an organization, especially a medium or high risk level organization, to implement the relevant standard. So as far as we're concerned, you can implement the security regulations by using 27000 series or by using PCI DSS if that applies to your industry, or by using other standards or the Israeli cybersecurity standard. Whatever standard you choose, which is applicable to your organization, and that's your professional discretion, may be suitable. We've even published a few guidelines to that respect, doing a gap analysis between the security regulations, our Israeli ones, and the ISO 27 or other regulators like the supervisor of banks who have their own specific specific guidelines on security. So if we're looking at the hierarchy, then the regulations are the baseline, and then you need to use whatever standard or whatever professional criteria is relevant to your organization. Now, one way we're going to enforce the regulations is through our new audit unit, and this is something that we've added to our enforcement department in the past year. It will start operating in the second half of this year, and we expect to conduct about 150 audits. Not all of them will be focused on security. They may also be focused on other privacy issues within an organization. And this will be a software type of regulation of enforcement. It will be an audit that is meant to assist an organization in finding out what needs to be better.
150 per year?
100,
You said 150
150.
per year?
Yes. Now, in case there's 150 in the next half year, 300 next year.
Alon isn't even looking, he's just taking notes. Alon, 150 per year. Yeah.
For 6 months. So that's one line of enforcement. The other one would be researching data breaches or severe incidents, and on that track it may be different. We'll be utilizing other branches of our enforcement department, and this will be something that may become more forceful.
Orly?
I'll just add that as an international company, obviously international standards is my preference. Obviously it enables us to work easier and across the board. I agree as to Dan's point is that for every company, no matter how big or small they are, it's better not to be on double standards or two laws or two regulations and so on. So I'm a big supporter of international standards, and I do think that some of them are very detailed, and they give additional benefits of being audited by a third party that gives the credit, the accreditation, and so on. So definitely that should be and we, as a company, we apply and comply with various international standards exactly from that direction. I would, when I speak to regulators, a lot of the time I'd ask, why are we not kind of including or addressing our people to a specific standards instead of adding additional regulation. Obviously, that's a burden. I do think that as a global market for companies in Israel, definitely startup nations, this is a benefit as well, the ability to apply or to comply with international standards. The GDPR, I do believe, will be, at least if it does not apply directly in Israel, would be a method of interpretation of what does apply. So just as additional context, for something that I wanted to say earlier about the GDPR, I do think that there's even kind of a guidance that you said that will continue to follow Europe in interpretation as far as that is concerned. So I do feel that's another side of
By the way,
regulation.
Microsoft, specifically in the industry more generally, are working on a standard that might actually align with GDPR. It's 27552, and you can get it on the BSI website already, although it hasn't been accepted yet. I think there's still like 6 months to go in the process, but BSI made the irregular step of actually publishing it for public comment. Gabe?
Yeah, we get this question a lot, and we heard it today as well, which is, if I'm an Israeli company or I'm outside the EU in general, and I don't comply with the GDPR even though it applies to me, what are the regulators going to do? And so I guess I wanted to ask you, Limor, could you envision a situation, it sounds like if there was a serious breach of GDPR, there would likely be a breach of Israeli principles as well. Could you imagine situations where EU regulators would come knocking to ask your help?
Well, it's possible since we have very strong cooperations with our colleagues around the world, with the international community of data protection authorities. I have to stress that we're empowered by the Israeli law and we are not empowered by the GDPR. That's actually a question that I get a lot in the past year. If we have a data breach in Europe, can we report to you here in Israel? No, absolutely not. That's not how it works. We do not represent the EU. We're not empowered by the GDPR, and we're not a point of contact for that. We are a point of contact for colleagues overseas, and we may receive concerns from them, and if there's a breach of Israeli privacy law as well, then we may consider enforcement.
It's interesting because according to the Privacy Shield framework, the previous safe harbor, the FTC does have jurisdiction over American companies not to enforce GDPR per se, but to enforce those companies' commitment to comply with similar standards. So here you have a slightly different structure. It is an adequacy framework, so it's an adequate regime for now. But that means that actually you can't enforce GDPR. You can enforce Israeli law and maybe try to help them through like the GPEN or...
Right. Well, the logic is that if Israel is an adequate country, then we have an equivalent of privacy regime, and then we can use that in order to enforce.
Yeah. I saw some more, yes.
A follow-up on the former question. Usually Israeli companies that are subject to both GDPR and Israeli law, if they suffer a data breach, they wouldn't know necessarily, and of course they wouldn't know it within its first 24 or 72 hours if the data breach refers to EU data or to Israeli data. So obviously those companies, and it goes back to Dan's comment before, would have double reporting obligations, if not triple or quadruple if they have to report to specific regulators like the supervisor of banks or the supervisor of the insurance companies. So how would you see the data breach handled in such an event? If it's an Israeli company headquartered in Israel that does have GDPR applicable and does have a lead data protection authority in the EU that it reports to?
Well, I think it's a similar thing. Even if we take Israel out of the equation, we have the United States and Europe, and you have data breach notification duties in the United States from the beginning of the 2000s, even before the GDPR started with it just a few weeks ago. So the double reporting duty is something that is global. It's not something that Israel is specially introduced. I think that as in recent cases we've seen the British ICO, the Canadians, the FTC, ourselves here in the PPA conducting investigations on the same facts of a case, and this is something that is possible and can be done.
Dan, you want to add to that?
Well, yeah, I've been into already a few breach or incidents in which we needed to, initiate a sort of a process in order to understand better what exactly do we need to do. And I think that it's important to go over this type of process to understand what a company goes through in such an incident. And I think just in a nutshell, you first need to understand that a certain discrepancy within your information system is a security incident. It may take time until you realize that it is a security incident. And then when you realize that it's a security incident, it may take additional time until you understand that it's a data breach, that it's a personal data breach. And then it may take additional time in order to understand what exactly is the scope of the breach data. Is it European data? Is it Israeli? Does it relate to others? What's the scope of it? So to get a sort of understanding, what type of notification do you need to provide and to whom, to which regulator? This is a process that can take time. And this is something that we are negotiating in data protection addendum because companies, the controllers require you to, for for example, I've seen some companies, data controllers, that require their vendors to provide them with a notice within 4 hours, 6 hours time, and those, I think that those that write down these requirements, which are not mandated by the GDPR, for example, they don't realize the extent of the process that a company needs to go through, potentially, not in all cases, but potentially can go through the whole process that they need to go through in order to understand the notification requirements that applies to them. So it may...
It's not because they don't understand the process, it's because the EU regulator requires them to notify within 72 hours, and the Israeli regulator requires us to notify within 24 hours in some
Yeah,
cases. So they need to get their back-to-back requirements from their...
well, again,
Yes, to be fair, we've stated in our policy 24 to 72, and in both our policy and the EU's policy by the Working Party 29, if there's good reason that you fail to report by the 72-hour mark, you can elaborate on that and add that to your report.
Yeah, I'm just saying from a practical point of view, those vigorous attorneys that counsel their controllers require a sort of additional requirements from the data processors. That's what happens in fact.
Not only on that issue.
Yeah.
Also on many others.
Yeah.
Can I ask a specific data transfer question outgoing from Israel? This obviously is important for European adequacy, because with adequacy, Israel kind of becomes part of the Euro data zone, if you will. So transfers from Israel are important. So one of the provisions in these quirky regulations from 2001 is that you can transfer data not only to Europe but to other jurisdictions or maybe companies that Europe allows data transfers to under those same conditions. And in the past there was an opinion of the data protection registrar that said that this includes transfers to safe harbor companies in the US. That fell through when safe harbor fell through with Schrems decision. Now we have Privacy Shield. So do transfers to Privacy Shield companies in the US, are they grandfathered in by this clause? Limor, that's for you. Don't look at Dan.
It's 2 minutes to 3. We're almost done.
Look, so the speaker...
Let's see whether Privacy Shield is going to withstand the EU scrutiny soon to be...
It's still valid. So I have to say, I promised them it would be a session in Hebrew, and they had to transition on the spot. So kudos for that. Thanks a lot for participating. I want to just remind you that tomorrow we have a full day here, a conference, the Israel Tech Policy Institute. We have great speakers. Alon will be there, the Israeli Privacy Commissioner, the European Data Protection Supervisor, Isabelle Falperotin, who headed the 29 Working Party and still heads the CNIL, speakers from the US, Terrell McSweeney, FTC Commissioner, and others. So we invite you to come to that tomorrow morning. We start again. Thanks a lot. Have a good afternoon.
I promised we'd have at least one winner who provided their email. Liron, pick a number between 1 and 20, please. God Levy.
Nice.